So this begins our discussion of Chapter 40. In Chapter 40, we have a number of new business entities with confusingly similar names. So we have already studied limited liability partnerships. In Chapter 40, we are going to study limited liability companies, LLCs, limited partnerships, LPs, and limited liability limited partnership, LLLP. All of these entities are different, and as I've said before in class, it's really important in light of their confusingly similar names. You take very careful notes, and when you take your midterm, make sure you are dealing with the correct business entity. So we'll start off talking about limited liability companies. Limited liability companies are actually a relatively new form of business. They've only been around for probably about the past 30 or 40 years. They have similar protections of corporations, but they were created to give smaller business owners some more flexibility in the way that they can run and set up their businesses. Just as we had when we studied partnerships, there is a uniform set of laws that were created by judges and lawyers to try to have the states adopt consistent laws regarding the way that limited liability companies would be operated and set up. The uniform law that governs limited liability companies that has been adopted by 14 states is called the Revised Uniform Limited Liability Company Act of 2006, or RULCA. Now, only 14 states have adopted RULCA to date, but that is because, as I said, this is a relatively new business form. So eventually more and more states will begin adopting this uniform act. Every state, however, has either adopted RULCA or its own statute that recognizes the existence of limited liability companies. All 50 states recognize this form of business. Limited liability companies tend to be the preferred form of business for those businesses that have just a few owners, and they don't want to go to the burdens of setting up a corporation. So let's talk about some of the characteristics of limited liability companies. First of all, the owners of a limited liability company are called members, not owners, but members. And anyone can basically become an owner of a limited liability company. So a member may be an individual, it could be a partnership, it could be a corporation, or even another limited liability company. They may all be owners and therefore members of an LLC. A limited liability company is formed by complying with the requirements of the particular state in which the business is being set up. In most states, limited liability companies are formed by filing what's called a certificate of organization with the Secretary of State of that state. One requirement when you have a limited liability company is that it must be reflected in the company name that you are that form of business. So the name has to either include the words limited liability company or the abbreviation LLC or something else that indicates to others that the liability of the owners of the company is limited as opposed to the general liability of a partnership. So we want to put creditors and people we're dealing with on notice that when they're dealing with this company, they aren't going to be able to look to the owners to satisfy the obligations of the company. That's all it takes to set up an LLC in most states, filing the certificate of organization and picking a proper name. However, the best practice is that most LLCs will and do have what's called an operating agreement. The operating agreement is an agreement among the members, the owners of the LLC, as to how the LLC is going to be operated and the members' relations to each other. There are very few, if any, LLCs that don't have this type of an operating agreement to govern their operations. Why do people like the LLC as a form of business entity? There are several advantages to using an LLC. One of the big advantages is with respect to tax treatment. An LLC may elect to be taxed either as a partnership or as a corporation for federal income tax purposes. They can pick and choose. For the most part, people tend to pick to be taxed like a partnership because that allows the income to pass through onto their personal returns. But for some situations, a corporate form of taxation might be best, but the LLC gets to choose what's best for it. The second major advantage of a limited liability company, particularly over a general partnership, is that all of the members have no personal liability for the obligations of the business. So usually when you set up a limited liability company, your risk of what you're going to lose is what you have contributed to the business. Whatever money you've put in, that's still at risk, but creditors of the company can't look to the members in most instances to collect on the obligations of the business. However, we can't get protection from our own torts that we commit, even if we commit them on behalf of a business. So an owner remains liable personally for any torts they may have committed while acting for the LLC. However, the other members are not. So in this regard, the limited liability company is a lot like a limited liability partnership that we studied previously. Only the owner who commits the tort is liable for that tort, and the business itself is liable for that tort. But the other owners are protected from the torts committed by one of the other owners. The final advantage of a limited liability company is that it provides flexibility in how the company is going to be managed. The owners of a limited liability company can choose to be either member managed or manager managed. If they choose to become member managed, that means that the owners, the members, are the ones who have the responsibility for the operations of the business. However, they can also just say, we don't want to bother with the management of the company. We want to invest, we want to work, but we don't want to be bothered with managing. And they can have an outside manager come in and manage the business for them. If they have an outside person come in and manage the business for them, that limited liability company is called a manager managed company. If the owners opt to be member managed, then each member shares equal rights in the management of the business. Now, we've spoken before a lot about fiduciary duties, and we saw when we studied partnership that every partner owes a fiduciary duty to every other partner and to the partnership itself. This is one of the things that changes with respect to a limited liability company. Only the managers of the LLC owe fiduciary duties to the company itself and to its members. If you are a non-managing member, you are an owner, but you're not involved in the management of the company, you owe no fiduciary duties to the LLC or to the other members. So managers owe fiduciary duties, but non-managing owners do not. In the case of Hecht versus Andover Associate Management Company, the issue in that case was whether the managing member of a limited liability company breached its fiduciary duty to the company and to the other owners by investing with the famous Bernie Madoff. I like to call Bernie Madoff Bernie Madoff, since he made off with everyone's money. In this case, there was a company who was one of the members of the LLC, and the company was a managing member. The manager chose to initially invest 100% of their funds with Bernie Madoff. At the time the lawsuit took place, their investment had reduced down to 25%. The non-managing members of the company claimed that the managing member had breached its fiduciary duties by acting recklessly by investing their money with Bernie Madoff without conducting due diligence. And what the other owners argued in that case was, if the managing member would have only taken the time to investigate the reports that Bernie Madoff was sending, they would have discovered his fraud. And this was true not only of this company, this was true of all of the people throughout the country who invested with Bernie Madoff. Bernie Madoff was running a pyramid scheme. He was taking people's money, and instead of investing in the stock market, he was using it to pay newer investors, just like pyramid schemes are set up. In order to cover the fact that he wasn't actually putting their money in the stock market, Bernie Madoff created completely false reports about where the money was being invested. If anyone, right, including the managing member in this case, but if anyone would have bothered to compare the reports that Bernie Madoff was issuing with what had really happened in the stock market on a certain day, they would have seen that he was making things up. For example, he would put in his reports that he invested, $10 million into a certain stock on a certain day. But if you looked at the reports from the stock exchange, no such investment was made. But everyone was so happy with the huge returns that Bernie Madoff was making for them, nobody bothered to step back and see whether what he was reporting was actually the truth. So the claim in this case was that by not verifying the reports being issued by Bernie Madoff and by not checking out Bernie Madoff thoroughly in the beginning when they invested the monies, that the managing member had breached its fiduciary duty to the others. And the court in that case held that there was enough evidence of mismanagement to support a claim that the managing member had in fact breached its fiduciary duty. That was a case where the managing member, who was being sued, had tried to get the court to dismiss the case early. So at this stage of the case, all the court was deciding was whether there was enough evidence to go forward to a trial. And the court held in this case that in fact there was. Now, another illustration of the fact that managers owe fiduciary duties to the other owners, but non-managing members do not owe fiduciary duties, is a case that I handled personally in my practice. This was a case of three young men who were advertising executives at a big New York City advertising firm. And at some point, they decided that they were going to leave the big advertising firm and form their own firm rather than continue to work for someone else. So these three hired a very well-known, high-powered New York attorney to set up the business entity that they were going to use to conduct their own advertising company. And that advertising company was going to be set up in California. They're going to be operating in California. And this lawyer chose the limited liability company form of business for these three, which was, I believe, the proper form of business to use. And he set it up so that the day after the company was set up, the three men became equal owners and shared equally in the profits of the company. Now, all was well and good the first couple of years of operation. They were doing really well. They were very successful. And then about the second or third year of operations, one of the three developed a very serious drug and alcohol problem. And it was really bad. This third member was not showing up for client meetings. He was being abusive to staff, so the staff was quitting, clients were leaving. And the other two members decided that they needed to remove this member from his position of a manager of the LLC. At this point, all three were equal managers, and also to remove him as an employee of the company. And the way the lawyer had set up the agreement, a majority vote of the members could accomplish both those things. They could remove a manager and they could also fire employees. So the two members who did not have the problem voted to remove the member with the problem as a manager of the company and fired him as an employee. But what the lawyer unfortunately had not provided in their operating agreement was a way for the majority to vote to purchase the ownership interest of the member who just had been ousted. So this member no longer worked as a manager and no longer worked as an employee of the company, but he got to keep his 1/3 ownership of the LLC. So now the other two members are the ones doing all of the work, all of the managing, while the third member is getting 1/3 of the share of the profits. Also, since this third member had been fired from the business and he wasn't working and he wanted to be working, he set up a competing advertising company. He went into direct competition with the limited liability company of which he was still a 1/3 owner. So the two members who were still in the limited liability company came to me. This case had actually been handled by another law firm, came to me and asked me to get involved in their litigation and said, you got to get us out of this mess. And I said, well, let me see your operating agreement and let me see what your rights are regarding this third member. And I reviewed the operating agreement and I concluded that they were entitled to have voted him out as manager. They were entitled to have fired him as an employee, but they had no right to force him to sell back his interest in the limited liability company. So they were stuck with him as a third owner and sharing in 1/3 of their profits. But then they said to me, but surely he can't compete with us. Right? He's taking business away from us from a company that he owns 1/3 of. And the unfortunate result in this case was, after they had removed him as a manager, the third member owed absolutely no fiduciary duties to the limited liability company or to the other owners. So he was in a position where he could go out and compete and take business away from the company with no liability to the company or the others, and also share in 1/3 of the profits of the company. So they were stuck with that situation, and the only thing that I could advise them to do if they wanted to remove themselves from the situation was to dissolve the company, to liquidate its assets, and to start up a new company with just the two of them, right? A brand new company. And unfortunately, they didn't want to do that because they felt at this point that the name of the LLC had established so much goodwill and such a good reputation that they wanted to continue to be able to use the name. But if they dissolved the LLC, the goodwill of the company and the name is something that would have to be sold and shared with the third member. So, as far as I know to this day, the third member is still out there competing with these two, taking business away from them, and yet sharing in 1/3 of the profit of the company that they fired him from. So, how could the lawyer have avoided that? He could have avoided that with a very simple clause in the operating agreement that said if a member no longer worked in the company, that the other two members could vote to force him to sell his interest back to the company and set out a formula in the agreement to calculate what the buyout price would be. It probably would have taken a paragraph and would have saved these two owners hundreds of thousands of dollars of attorney's fees and this terrible situation where to this day they are still forced to share profits with someone who is in active competition with them. Right? The difference being they owe fiduciary duties to the third member because they are managers of the company, but the third member now owes absolutely no fiduciary duties to them. All right, now, every business form that we set up, we hope we're going to make money with. So, how do members share in the hopeful profits of a limited liability company? Now, first and foremost, the partners can say, or the members can set it up any way they want. They could put in their operating agreement how profits are to be distributed. However, if they do not do so, the default rules of RULCA, or the default rules of the statute of a state that has not adopted RULCA, are going to control. The default rules of RULCA are that members share profits equally, regardless of the difference in their capital contributions and regardless of the amount of time that they devote to managing and running the business. Right? So this is the same default rule as we saw with partnerships. The default rule, regardless of how much money you put in, regardless of how much time you devote, profits are shared equally among the members. The other default rule is that no member is entitled to a distribution of profits prior to the time that the LLC is dissolved. In absence of an agreement, there is no right to take any distribution of profits out of the business until the business is over. So, another strong reason to have a written agreement governing the operations of the business. Right? Most people don't want to wait until the business is dissolved before they can share in any of the profits of the business. All right. What happens when a member wants to leave a limited liability company? And how does a limited liability go out of business? And here we have the same two terms that we studied with respect to partnerships. A member dissociates, but the limited liability company keeps operating. That's when one member or two members leave. But when the limited liability company itself goes out of business, that is called a dissolution. So a member dissociates, the limited liability company itself dissolves. Now, there are a lot of similarities here with respect to members of an LLC and partners in a general partnership. Just as we talked about with partnerships, all members have the power to leave. We don't force them to stay in a business they don't want to be in, but not all members necessarily have the right to dissociate. So everyone has the power, but not necessarily the right to dissociate. And just like we saw with partnerships, dissociation of a member of a limited liability company may be wrongful or may be non-wrongful. With respect to limited liability companies, however, as in contrast to partnerships, regardless whether the dissociation was wrongful or non-wrongful, the dissociated member is not entitled to receive the value of his or her interest until the LLC dissolves. If you remember when we studied partnerships, a non-wrongfully dissociating partner was entitled to receive the partnership interest within 120 days of notice. Right? That is not the case with respect to limited liability companies. That member, even if the dissociation is wrongful, has to wait until the LLC dissolves in order to be paid his or her interest. And again, this is something that can and probably should be changed by the operating agreement. But if there's no agreement, this is the default rule. If and when the limited liability company elects to dissolve, the the LLC goes into a winding up process, similar to what we talked about with respect to partnerships, which involves finishing ongoing business and then liquidating the assets of the LLC. Once the LLC's assets are liquidated, the proceeds get paid first to the creditors of the limited liability company. Creditors always get paid first. Then the proceeds go to return the members' contributions. So if the members have contributed different sums of money, they will get those differing amounts returned to them. After the creditors are paid and after the members' contributions are returned, if there's any remaining sums to be distributed, those sums will be distributed to the members in proportion to how they share profits. Let's take an example about the distribution of profits upon a dissolution. Right? We're going to assume that Peterson LLC dissolves. Peterson LLC has 3 members, Mary, Jennifer, and Jacob. Mary has contributed $20,000 to the LLC. Jennifer contributed $15,000, and Jacob contributed $10,000. There was no agreement between the members about how they would share the profits of the business. Right? So remember, in absence of an agreement, we're going to go to the default rules of RULCA for how those profits are shared, which in this case would be equally, even though they made differing amounts of contributions to the business. At the time of the dissolution, Peterson LLC has creditors that are owed $40,000, and Peterson LLC has liquidated assets in the amount of $100,000. So, given the rules we've just taken a look at, how would the $100,000 be distributed? Right? You might want to write this down, see if you can follow. Remember, creditors get paid first, and then return of the contributions of the members, and then the balance, if there is a balance left over, shared how profits would be divided. Okay, so here's how the proceeds would be distributed under our scenario. First, $40,000 would go to pay the creditors. And as I say, creditors always get paid first. Second, there would be a return of each member's investment. Therefore, Mary would be paid $20,000, Jennifer $15,000, and finally Jacob $10,000. And then we would have a balance remaining of $15,000. That $15,000 would be distributed evenly among the members for $5,000 each, since they had not made an agreement as to how to share profits. So therefore, the final distribution would be $40,000 to the creditors, $25,000 to Mary, $20,000 to Jennifer, and $15,000 to Jacob. Now, the second case that I asked you guys to brief for this lesson was the McDonough versus McDonough case. And the reason I assigned this case is because this provides a good example of a member being required to wait until a limited liability company has been dissolved in order to be paid their interest in the business. Okay. This was a limited liability company that was owned by 3 brothers. As we see, it's always a problem when you go into business with your family. And there was a falling out between the brothers. And Mark wanted to leave the company. but he wanted to leave and get his interest paid out. So this company was named TASC, right? Another really poor choice of names for a company because we don't know from its name what it actually does. And Mark argued, in order to support his position that he should be paid out relatively soon, was that the limited liability company was required to be dissolved on a date certain that was very near. The other two brothers, on the other hand, claimed that under the operating agreement of the LLC, they could continue the business past the date that Mark was arguing the company had to be dissolved on. And the court disagreed with Mark's position and agreed with the other two brothers. The court found that the limited liability company's operating agreement allowed a majority of the members to vote to continue the company as long as they wanted to, which the other two brothers had done. So as a result, if Mark leaves the company, it's not required to pay Mark his interest until if and when, if ever, it dissolves. So very risky to not have an operating agreement in an LLC that provides that when a member leaves, there's a procedure for that member being paid out an interest in, an amount and time frame that the company can withstand. And again, this is one of the things that if this is something you talk about when you're setting up your business, everyone is going to be motivated to be fair, right? Because they're going to be saying to themselves, yeah, maybe one day I'm going to be the one who wants to leave, and I'm certainly not going to wait until the company is dissolved in order to be paid my interest. I'm going to want to be paid relatively soon after the time that I leave. So since no one knows how the provision is going to operate, who's going to be leaving and who's going to be staying, everyone is motivated to be fair. But here, for example, in the McDonald case, at that point there was bad blood between the owners. Right? Mark wanted to be paid immediately, and the other two brothers hoped that he had to wait forever to be paid. Right? And they were the majority, and they can probably arrange for that to happen. Right? So it's very risky not to have these things thought through at the time you're setting up your companies and to make sure that you have it in writing. So that is the conclusion of the discussion of limited liability companies. And next lesson, we will start talking about limited partnerships and limited liability limited partnerships.